One defendant took a plea deal and avoided jail. Another refused a plea deal and ended up with 20 years in prison. And now a third defendant appears unwilling to take any deal at all because accepting one could cost her everything that's funding her defense. 3 completely different cases, different outcomes, but together they reveal the real power of plea deals inside the criminal justice system. When people do the most, I do the analysis. Let's go. Today we're talking about deal or no deal, not a game show, but as one of the biggest decisions that a defendant can make. Because whether you accept a plea deal or reject one can completely change your future. And we're seeing that play out right now in the cases involving Chiron Moore, Quadajah Johnson, and Kadesa Sayles. Now, before we continue, I just want to say that I know these are all very different cases with different facts and circumstances. What connects them is the role that plea deals played or didn't play in the final outcome. Let's start with the case of Chiron Moore. Chiron Moore faced criminal charges tied to an incident involving a staff member and an inappropriate relationship. Originally, prosecutors had more serious charges on the table, including a felony, causing him to face up to 15 years in prison if found guilty. But Moore ultimately accepted a plea deal. He pleaded no contest to misdemeanor charges involving trespassing, malicious use of a telecommunications device, and in exchange, the more serious felony charges were dropped. The final result? Well, let's listen in.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. You understand that, sir?
Yes, sir.
Mr. Moore, to the charge of malicious use of a telecommunications device, how do you plead?
No contest.
To the charge of trespass, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I place the defendant on an 18-month probationary term, 18 months under the prosecutor's deferred sentence. You are to pay $555 fines and court costs. You will take those court costs out of the bond.
Judge Cedric Simpson said incarceration was not appropriate under the circumstances, but he warned that violating probation could change that immediately. So in Chiron Moore's situation, the plea deal dramatically reduced the risk. But plea deals don't just matter when someone accepts them. Sometimes the biggest consequences come when someone turns one down. And that brings us to Kadesa Sayles. Kadesa Sayles refused a plea deal that would have resulted in a 5-year sentence. Instead, the case went to trial. And after she was convicted, well, let's listen in. Kadesa Sayles is a young woman, a mother of 6, who led a double life in the state of Florida, and she thought she could outsmart the system. Well, I don't know who pumped her head full of confidence, but she made what might be considered one of the worst decisions of her life. And then this happened.
The case took place in Florida. The defendant is Kadesa Sayles, a mother of 6. She was charged with impersonating a telecommunications company employee and carrying out SIM swap fraud, facing 18 felony fraud counts. During the pretrial phase, prosecutors offered a clear deal: plead guilty in exchange for a 5-year sentence. She refused. She chose to go to trial. She believed she could win. In court, the evidence was presented piece by piece. The fraud methods, money trails, and victim testimony all worked against her. At the same time, her social media activity was repeatedly referenced. High spending, lifestyle posts, and luxury purchases stood in sharp contrast to the losses suffered by the victims. The jury ultimately found her guilty on all counts. The judge then announced the sentence: 20 years in prison.
She had to sit down for 20 years. Now, that's a very hefty prison sentence, and it's a massive difference. And again, this does not mean that every defendant should automatically accept a plea deal, but it does show how high the stakes can become once a case moves into trial territory. Because once the protections of a negotiated agreement disappear, the sentencing exposure can increase dramatically. And this is why prosecutors use plea deals as much as they do, because it's been reported that 90 to 95% of cases end up with a plea agreement. A plea deal gives certainty, and trials bring risk for everyone involved. For defendants, you may beat the case completely or receive a much harsher sentence. For prosecutors, they avoid the uncertainty of trial. So every plea negotiation becomes a calculation. What are you willing to risk? Now let's talk about the Quadajah Johnson case.
Quadajah Johnson and Romika Blackman each have a child with witness one in this case. All three parties got into a dispute near a school. Johnson threatened Blackman multiple times in front of witnesses. Johnson then retrieved a handgun, shot Blackman multiple times in front of witnesses. This is according to the Cook County. This was filed for the murder charge, the first degree murder charge. So again, Johnson threatened Blackman multiple times in front of witnesses. Johnson then retrieved a handgun, shot Blackman multiple times in front of witnesses, and then we know, sadly, Blackman died. Johnson murdered Blackman after Blackman had just dropped her child off at school. Johnson celebrated the murder immediately after. Johnson was undeterred by the presence of witnesses, public setting, broad light near a school, and near many children. Multiple civilian calls to 911 before and after the murder. It basically goes on to say that she deserves to be held behind bars because clearly she doesn't care about the harm, and based on the previous circumstance that happened, nothing would stop her, is essentially what it says.
According to statements from her family, Cordasia is not planning to accept the plea deal. But what makes this situation different is why she won't. Her legal defense is reportedly being funded through a concealed carry weapon or CCW related insurance coverage that's connected to a self-defense claim. And according to public statements, accepting a plea deal to something like second-degree murder would contradict the claim of self-defense, which would potentially end the financial support of her defense and possibly create financial consequences that are tied to that coverage. So unlike Chiron Moore, where a plea deal actually reduced the risk, or Kadesa Sayles, where rejecting a plea deal led to a much harsher sentence, Quadajah Johnson's situation, it appears to be tied to something else entirely. Whether taking a plea deal could collapse the structure that's currently supporting her defense. Now, before I play this next clip, I want you all to pay very close attention to what's being said here, because this completely changes part of the conversation that's surrounding plea deals and self-defense coverage. Up to this point, a lot of people have assumed that accepting a plea deal automatically means losing your CCW insurance protection or being forced to repay legal expenses. But according to a CCW SAFE spokesperson, Cris Cunningham, that is not always the case. In this interview with Cunningham, she explains that CCW SAFE does not seek reimbursement from members who plead down to a lesser offense. She goes on to say that this policy separates them from a lot of the other CCW insurance providers nationwide. Now, I'm not presenting this as any type of advice or sponsored information. Every case depends on the specific facts, the policy language, and the circumstances involved. But this clip is important because it shows that plea deal decisions can be far more complicated than people realize, and assumptions about the automatic loss of coverage may not always be accurate. Take a listen to what she had to say.
I've heard of basically insurances that you can get when you have carry, like a
Sure.
carry conceal license or something like that. How is this different?
So the difference between us, CCW SAFE, and other companies in this industry are we are not an insurance. A lot of those companies have a third-party insurer, and just like you buy car insurance, and your agent finds you a company to insure you, that's basically what's going on.
Okay.
For us, what was done when this company was set up is we have a captive insurance. We have insured the company itself. CCW SAFE is insured. We're not insuring you as a person.
Yeah.
So you join us as a membership, we're insured, you're not. The benefits of your membership provide you with these things.
Gotcha.
That's big because if you do have a result in your case or in your incident that is a guilty plea or a guilty verdict, which none of us want, but we can't guarantee the outcome, we can just support you through it.
Right.
You can be sent a letter demanding restitution for everything they spent, because it is illegal, no matter what state you're in, to insure a criminal act. It's simply a business model difference,
Right.
but it's huge to our members that they're never going to get a letter from us, ever. They don't ever have to worry about getting a letter from us demanding money back.
Right. And especially if, you went through this terrible situation, the courts didn't sway your way, and now you owe us all your money.
Now you have to pay us back.
Yeah. You guys aren't going to do that to
No,
people.
we will not do that. That
That's
will not
amazing.
happen.
Yeah.
So when you look at all three cases side by side, you start to see how complicated plea decisions can really get. Chiron Moore, he took a plea deal and avoided prison. Kadesa Sayles, she rejected the deal, received a much longer sentence after trial. And Quadajah Johnson, at this point, she appears unwilling to take a deal at all, because accepting one may come with financial and legal consequences beyond sentencing itself. Add that to the fact that her case is currently on pause because the state prosecution is appealing to the Illinois Supreme Court, and we're waiting to see whether or not the Supreme Court is going to accept the case or if they're going to deny it after the PLA has been filed. 3 cases, different outcomes, and 3 completely different calculations. And this is why plea deals are one of the most powerful parts of the criminal justice system. Because these decisions are rarely just about guilt or innocence, or even about prison time alone. Sometimes they involve financial pressure, public image, legal strategy, mandatory sentencing exposure, or the ability to continue fighting the case at all. And depending on the circumstances, saying yes to a plea deal can save you, and saying no can change your life forever. So when people ask, why would someone take a plea deal? Why not just fight the case at trial? The answer is never simple, because as these 3 cases show, every defendant walks into that decision with different risks. They each have different pressures and very different consequences on the line. But at the end of the day, even with all the planning and preparation that took place, CCL, restraining order, and CCW insurance, Quadajah Johnson was not prepared for the testimony and courage of eyewitness number 3.
She's the one who shot her. Restraining order, but she shot her.
If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. If you were facing trial, would you take the certainty of a plea deal, or would you risk trial hoping for a better outcome? Meet me in the comments. We can continue the conversation there.